The inheritance provision for Family and Dependants Act 1975 enables certain categories of people to bring a claim against the estate of a deceased relative or someone on whom they were financially dependent during their lifetime for reasonable financial provision in circumstances whereby adequate provision hasn't been made for them under the will or under the intestacy rules, which determine how an estate is divided in the absence of a will. Eligible people might include a spouse or civil partner or child of the deceased.
And does the Act actually have teeth? Are people using it to bring claims?
Absolutely. More than 1,000 claims were brought between 2010 and 2013, many of which were successful. However, potential claimants should be aware that each case is fact-sensitive and heavily dependent on the discretion of the judge, who must ask themselves two questions in making a determination under the Act. The first was provision made unreasonable, and if so, what is reasonable in all the circumstances?
Presumably then, with second and third marriages more commonplace, these kind of claims are on the up.
They are. In these cases, there is invariably distrust and dislike between the children and their new step-parent, and equally there can be animosity between new step-brothers and step-sisters, which gives rise to claims from disgruntled children seeking to ensure that they recover what they consider to be reasonable provision from their deceased parents' estate. Traditionally, the courts have been somewhat sceptical about claims from able-bodied adult children, but recent case law suggests that they are starting to have more sympathy towards cases of that nature. The spouse or civil partner of the deceased, be it second, third, fourth marriage, is also entitled to bring a claim under the Act. In these cases, the applicant, spouse or civil partner, various factors are taken into consideration: the age of the applicant, the length of the marriage, the contribution of the applicant to the welfare of the deceased's family, and also the court thinks about what the applicant might have received had the marriage been terminated by divorce as opposed to death, that last factor being known as the divorce cross-check.
Is it possible to make a claim if I was only living with rather than married to my partner?
Yes, providing you were living in the same household as the deceased for the 2 years immediately preceding their death. However, it should be borne in mind that whilst a spouse or civil partner is entitled to reasonable financial provision in all the circumstances of the estate, the other categories of applicant, including cohabitees, are only entitled to what is reasonable for his or her maintenance.
So, what are the key elements to increase the chances of a successful claim?
A strong, demonstrable financial reliance on the deceased. The court will take into consideration not only the needs and resources of the applicant, but also those of other applicants and beneficiaries. The size and nature of the estate is a key factor, as is any existing obligations or responsibilities that the deceased may have had towards other beneficiaries or applicants. For example, a spouse or civil partner is likely to be entitled to a greater share of the estate. An application under the Act should be brought within 6 months of the grant of probate being issued.